Welcome back. We are live. This is Jonathan Rossi. I'm the co-host and the co-founder of SIA, Cybersecurity Awareness. We are on our global tour and we are continuing this tour. This time we're going to keep it in Africa and we're going to hand that over to Grace, my friend in Nairobi. She's going to take over this conversation and do a little bit of talking on data protection, cybersecurity, and I'm actually excited about this one because Desmond's going to join us. Amenda from South Africa, Grace, you're in Nairobi, and Jonathan, I'm in Los Angeles, and I'm going to hand it over to you, Grace. Thank you very much, and everybody, please enjoy. And also, please ask questions. We love an interactive session. They all want to get to know you. If this is a real world of normalcy, we'd all be able to break bread and possibly have a drink or dinner together. But since we can virtually do that. So I encourage all of you to engage with the conversation that's happening right now. So with that, I hand it over to you, Grace. Thank you.
Thank you so much, Jonathan. Hello from Nairobi. Hello, everyone. Thank you so much for joining us in this topic of data protection in Africa. What are the legal regimes and subject rights? Now, the topic, first I have to apologize because it's time to go to bed in Nairobi, and I am getting interruptions from some people here. So if you see them creeping into the conversation, you will just know what it is that. So the question of data protection in Africa has a lot to do with data privacy, which is really a global issue. But the question of data protection in Africa is really like trendy right now, with around 25 countries, probably out of the 54 countries already with a data protection law. Kenya effected its law last year. So, you know, privacy concerns, there have been privacy. And one of the issues has been to do with arbitrary misuse of information, where you go register, say you're buying a mobile phone, that information is necessary. And then shortly you start getting unsolicited marketing messages, some coming in as early as 5 a.m. or at 3 a.m. in the morning. And if you're a light sleeper, then you start asking, where did they get these messages? For those of you who are in East Africa, and especially in Kenya, we have the threat of Al-Shabaab. And so there is a practice that you must go through security checks in practice. All buildings, including in churches and in hospitals. And so whenever you do that, you need to leave your identity card at the entrance. And when you do that, then you don't know who is in possession of your data, but it's out there in the open. So there are issues of control of data and the rights of the data subject. Again, I'll be asking my panelists to tell us who a data subject is, to give us more details as a natural person, and the right of that person to be informed. When you give your data, when you're entering a building, do you have a right to be informed how it will be used by a data controller or a processor? And we have of course, we only think of the government holding this data, and yet there are other people like the guard at that gate who mans that data. So in this whole scenario, there have been talk about the three protagonists when it comes to data protection. Number one is the data subject, who is the owner of the information that is being shared. The second protagonist, of course, is the data controller. And this one determines the purpose and means of acquiring that data, for example, a bank. And of course, we have the final protagonist, who is the processor, and the processor collects, records, and organizes and discloses data collected. So we are going to be listening to very interesting speakers, and I'm going to ask them to introduce themselves. I didn't say, my name is Grace Githaiga. I am based in Nairobi. I convene a network called the Kenya ICT Action Network, or KICTANet. KICTANet is a multi-stakeholder platform that has everyone in Kenya who is interested in ICT policy and regulation. And what we do is that we ensure there's a public interest in laws that are being generated. And so any law in this country that has to do with ICT, we have participated. And we are very strong in advocating also for the balance between human rights and need for regulation, or the need for regulation with freedom of expression and such things. So I also host a talk show on the national broadcaster, the Kenya Broadcasting Corporation, and it's on technology issues. It's called Take on Tech, and we bring in technology experts to break down issues for ordinary citizens to understand and engage. So welcome, and I'll ask my panelists to introduce themselves. I'll start with Amenda. I will not pronounce your second name because in broadcasting, they tell us you have to be very careful not to offend your speakers by mispronouncing their names. So, Amenda?
Okay, thanks, Grace. Hi, everyone. In this late hour, I think the people that are actually connected at this hour are real data privacy enthusiasts. So just to introduce myself shortly, I am Amenda Makhetha, and I am an attorney by profession. I specialize in, and I absolutely am very passionate about data protection and cybersecurity. And I operate primarily in Africa and a bit in the Middle East. So I've also been someone who was following very closely over the past couple of years, you know, the oncoming of the GDPR and all that, and it's really sparked my love and my passion for the area. So it's something that I'm currently specializing in. I work for a telecommunications company currently, and I also run my own consultancy insofar as data protection is concerned. I'm also an author, and I'm a daughter, you know, and a friend. So, but that's basically me. I don't want to bore you with my long bio or profile. For our purposes tonight, I'm here to talk about data protection. It's what I'm passionate about, and I'm looking forward to it.
Oh, thank you so much. Desmond, over to you.
Hi, my name is Desmond Israel, as in the country Israel. And it's good evening from Ghana. So I'm a practicing lawyer, and before I became a lawyer, I have been in information security for about 15 years as a penetration tester and a vulnerability assessor. I moved into privacy sometime in 2015, and since then I haven't regretted. I founded a company called Information Security Architects, and we currently the gold partners in Africa for Rapid7, the security company. So we provide service in addition to security testing and security consulting. So I come to the table from both worlds, as the one who's trying to gain access to the data and the one who is trying to protect the data as well.
Okay. All right. Great. Thank you so much. So we'll go straight now into our conversation. And I think the first question is to Amenda. Considering that you're a data protection enthusiast and somebody who's been working in this area, including studying, could you please give us the broader picture, a landscape of data protection in Africa? And you know, you could highlight anyway, just deal with that first.
Okay, so I think you know, often because we talk about the subject so much and we deal with it so often, we take for granted that everyone we engage with actually understands what we are talking about when we talk about data protection or data privacy, and it's actually not the case. You know, a lot of my family members, even now, when they have to explain what I do, they can't really explain. Safe to say, oh no, she's an attorney, so because that makes sense. Everyone knows what that is. And that means, one, that there isn't actually awareness about data privacy, right? Whether it's within our communities, within our circles, or within our country or continent, you know. But also it means that we need to raise up the volume insofar as these types of conversations that we are having here. And we need to raise up the volume on broader platforms, you know, in schools, from primary schools to high schools, etc. But when we talk about data protection, right, we are talking about personal information that needs to be protected. So it dates back to our constitution. All countries have constitutions, and a lot of the countries, and I'll say a lot of them because, believe it or not, I've encountered some countries that actually don't have this right in their constitution. But most constitutions have afford you as a citizen of the country the right to privacy. So data privacy laws, or data protection laws as one would call them, the term is used interchangeably, and that's a discussion for another day, actually stem from that right to privacy of your information, right? So from that right that has been given in constitutions, laws have then been created to actually put into effect the right that has been afforded to you by the Constitution. And then we saw, before we had seen some clauses in Consumer Protection Acts, we'd seen some clauses in Electronic and Transactions Acts, we had seen some clauses in telecommunications legislation, etc., etc. But now a lot of countries, and we've primarily borrowed from Europe, have actually created legislation, national legislation, protecting the personal information of its citizens. And another reason why this is very important at this current time is because of the advancements in technology and the creative ways in which organizations are actually able to utilize your personal information. We've heard the term said that data is the new oil. And it's now the biggest commodity. But I think people don't really understand quite as yet what that means. So your personal information is a very, very, very valuable source or asset. And organizations can make a lot of money by using your personal information. You gave a nice example there, Grace, earlier about direct marketing and how you'd be sleeping at night and you're getting SMSs. I understand the SMSs for direct marketing. Sometimes you get SMSs that say you have won, right? And click on this and get this. Who doesn't want to win? So it's between you and I, we understand that, that is not a valid SMS, but the ordinary citizen won't really understand sometimes that that's actually a fluke. It's not something that's valid, right? And then they fall prey to these scammers that are actually trying to take advantage of them. So the question is, how are they getting our personal information, right? Clearly, they've seen the value in our personal information. And obviously, there are persons, organizations that we have shared our personal information with that have not really done what they're supposed to do with our personal information, which is actually to protect it. Now, the purpose of these laws is to make sure that what organizations actually do with our information is regulated, and that we have a leg to stand on in cases where your information is actually being, at the disposal of an organization. If I now need to do something about them not actually using my information the way they're supposed to be using my information. I'm trying by all means as I speak to remove the legal jargons that we normally use when we talk about these terms, so that when Desmond talks, you understand exactly how lawyers talk. Yes, I'm trying to just simplify it. Basically, it's your information that identifies you, that is valuable to organizations, that needs to be protected. So when we talk about data privacy, we are talking about personal information that identifies you as a data subject, that needs to be protected and needs to be processed in a lawful way or in the right way by organizations.
Okay, I was actually going to ask you to define who a data subject is, so that you don't assume that we all understand. Maybe just in a sentence before we go to Desmond, define for us who a data
Okay,
subject is.
so when we talk about a data subject, we are talking about you and I, right? A data subject is a person. So it's a person with a name, a surname, with, an identification, right? So it's an identifiable subject. So it's an identifiable person. And I say that loosely because across most legislation, when we talk about a data subject, that's what we are talking about. Here in South Africa, there is a bit of a difference to other legislation that's around the world. With our POPI, which is Protection of Personal Information Act, it actually refers to the protection of information, not only for natural persons, so data subjects just as myself, but it includes juristic persons. So that's a bit of a different addition to the normal definition and the normal scheme of things. But it's very rare to find legislation across the world that talks on data protection that actually also includes juristic persons. And by juristic persons, we're referring to companies and organizations.
All right, thanks. Desmond, we come to you, and it's to take it up from where Amenda has left. And she talked about the need for people's information to be handled in a lawful way. And take us from there. What legal regimes like in Africa?
Okay, so I missed the connection at a point, so I don't know if Amanda touched on the fact that we have about 50% of the countries on the continent having data protection laws. Concerning the fact that privacy laws should be rooted in constitutions, we also have about 23 countries in Africa having privacy laws as part of their constitution. And this stems from Article 42 of the Universal Declaration on Human Rights, where privacy to correspondence and communication is actually part of the natural rights of a person. So in dealing with the legal regime, you are actually looking at a scenario where if persons should have the rights that have been given to them, these natural rights have been given to them, flouted, or one way or the other, there is a violation against that right, how are they going to seek remedy, for instance? So you're more interested in looking at a jurisdiction that is actually taking these rights seriously. So when you talk about the legal regime, if privacy was a dish, you are looking at the temperature and the pan in which that dish is prepared. So that is exactly what the regime is if we are breaking it down. So you look at privacy from the constitutional provision point of view. You look at privacy as a substantive law, what most of us will call an act of parliament. And this is what the 50% of countries in Africa has done so far. They've been able to go to parliament, they've debated it, they've asked themselves, do we really need to give people these rights? Do we need to enforce it? Do we really need to set up institutions to manage this? And they have agreed, and they have passed those discussions into law. So we have various data protection laws across the continent. Africa is not left behind like people think. I mean, 50% of us are making progress. And then you also look at it from the point of view where agencies that have been set up are making efforts to kind of like provide for these sort of data protection rights. So they don't have it as an act of parliament. They have it as a regulation. So in the case of Nigeria, for instance, where NITDA has passed the regulation, that regulation is binding, but it was passed because an agency passed it. So if you look at the hierarchy of laws, it's about the constitution, the substantive or the act of parliament, and then the regulations. So if you're listening to us, you're looking at a picture where we want to make sure that there's a strength of that privacy practice, or that privacy regulation has the strength from the upper side, which is the super law, which we all call the constitution. Now, what would the legal regime provide? First key thing that should come into your mind: how are these rights going to be enforced? So you're looking at constitutional courts, you're looking at human rights courts, you're looking at maybe an ombudsman, the data protection and laws. You are looking at the opportunity for. We have in Africa, for instance, we have problem with volumes of poverty, and people find it difficult to even go to the courts. They are intimidated even to go to lawyers and pay for. So you are looking at a regime that also supports civil rights and work. The previous speaker, Teki, spoke about Africa Digital Rights Hub, which is a hub I'm a volunteer on. And these are things that, you know, you push, you work on them because people don't have the resources to even look out for themselves. So the legal regime must speak to a bigger body of constitutional courts, human rights courts, the independent body that deals with enforcing the Data Protection Act, if there is one in place, and civil society, making sure that people can actually have their privacy respected.
Very well articulated, Desmond. I want to take it from there and back to Amenda. Desmond has told us that half of African countries are already, you know, either have a data protection law, and within that, they also have privacy laws in the Data Act. And I'm just wondering, in those countries that have data protection, is there something you know, do we have patterns out of that? Or would we say, are there certain data protection principles that those laws have adhered to?
All right, that's actually quite a good question. And I think in respect of privacy legislation, what we have seen as the growing trend, especially within the African context, is borrowing from the European data protection laws. So we all know that Europe is quite, ripe and mature when it comes to data protection laws. They had the EU directives before, and they now since have had the GDPR, the General Data Protection Regulation, which was passed. Was it 2 years ago now? It feels like time has gone past me. 2018, I think 25 May. Yeah. So a lot of the legislation that has come out of Africa has actually borrowed from the principles in the GDPR. So there are common principles that you'll find across most of, if we're talking about the African context, there are common principles that you will find across our legislation, and to a very large extent, they read exactly the same. So it's consent, the principle of consent. When we talk about the principle of consent, we're talking about if a company wants your information, you need to consent to them using your information for a particular purpose and in a particular way and for a certain period. Now, before, we would have had consumer protection laws that talk about obviously similar things to what companies are allowed to do when it comes to your information. But what's specific about privacy legislation, it introduces the notion of explicit or informed consent. So as a consumer or as a data subject, as a citizen, I need to know exactly what you will be doing with my information as a company, right? So that's one principle that's found across all privacy legislation. Another one is the principle of security safeguards, right? So as an organization, you need to make sure that you actually protect my personal information, and that the standards that you are using within your organization to protect personal information is of the same caliber as is expected of the industry in which you are operating, for example. So that's a common one, and it's a big one because, and obviously Desmond would know a lot about that because in his previous life, he was dealing with making sure that companies don't succeed in protecting our personal information. So he would have a lot more information on that principle, right? So that's where we have what a lot of people will read about. They will see whichever organization has leaked 16,000 or 1.6 million information belonging to its customers. There's been a data breach in such and such an organization. They've been held ransom, etc., etc. So we see a lot of those. That is covered by the security principle in the data privacy legislation. They call it security safeguards, right? Another one that you'll find across is processing limitation. So that basically says that you're not allowed to process my information for anything outside of what you originally took my information for. So I'm trying to simplify that. So if an organization takes my information and they say they will be using my information for A, B, C, D, that processing limitation says you must make sure that you only utilize the information that I gave you belonging to me for A, B, C, D, right? Another one is, I think there's about 8 principles that you'll find everywhere. Data subject rights is also one of them, which we touched on a bit, and we touched on the data subject, but I think we'll also touch on data subject rights because that's one area where people need to be very well informed. What rights do I have as an individual against an organization that actually has my information, right? So data subject rights talks, well, maybe we'll go into detail with that one. I won't go into more detail. And what other principle is there that's common across?
We can also look at the compatibility with further processing.
Yes. Yeah.
Compatibility with further processing. Yeah.
Go on.
And then the subject. Okay, the compatibility with further processing. So if information, like Amenda said, is collected for one reason, and you intend to work on it, and mind you, processing here is defined in law variously. In Ghana, there's a very broad decision. There's a very broad definition for processing. It actually includes even distributing the information. So if you took the data and worked on it for one purpose, and you intend to work on it for another purpose, what the principle of data protection is saying that it has to be compatible. That further processing must be compatible with the initial purpose of collection. So for instance, if an employer collected an information from an employee and for the purposes of the employment contract, and then there is an insurance policy that would help would go to the benefit of the employee, giving the information to a third-party processor to process that insurance and make sure the payments are made to the employees must fit into the ambience of further processing. So that is where you look at it when you speak about the further processing. And then there is the openness principle, which also ensures that the information that is being collected is not secretive. It also, you have to ensure that the processing regime that is being used is open and people would be able to make access rights to them. We'll speak about the data subject rights, so there's no need belaboring the point at this stage. You can also look at the data subject participation to the subject rights. So yes, that's in a nutshell. That's what the principles are about.
Okay, I want to ask those people who are following the conversation that if you have any question, please type it into our chat box, and we will ask the panelists to respond to that. Now, you touched on the principles, and I think one of the key, is on the rights of the data subject. And I think that would be of interest to a lot of people. So I think, Amenda, you'll take it from there and tell us, what are these rights and how practical is it to provide, to allow the data subject to have these rights. And I would also be interested to hear, like in countries that have had a data protection law for a while, how this is done practically.
Okay. All right. So I'll answer the first part and allow Desmond also to come in here. So it's a very interesting area. It's a broad area, and it's actually quite demanding on organizations. A lot of organizations, what I've found that I've worked with, where they have challenges the most is ensuring that data subject rights are actually protected, because it requires that certain systems be changed insofar as how you've been operating. It requires that you clean up data, and it requires that you set up an office that's actually accountable for data protection, so that data subjects' rights are actually protected by your organization. So when we talk about data subjects' rights, we are talking about the right to be informed, right? So you would have seen, a lot of people would have seen now when you go onto a website, maybe we can use the nice example of Facebook, right? If you go onto a website, a Facebook website, under their policies on their terms, they'll have a privacy policy. Now that policy will tell you exactly what Facebook, or it's supposed to tell you exactly what Facebook will be doing with your personal information. So it tells you what they do with your information firstly, it tells you what information they're collecting from you, then what they will be doing with that information from the time they collect it right to the time where that information is deleted, right? So data subject rights, one of the first rights you have as a data subject is the right to be informed. You have the right to know what an organization is doing with the personal information that they have in their possession belonging to you. Secondly, you also have the right to access that information. So a lot of people don't actually, implement or enforce this right. But if I belong or was working for a certain company, right, and I've now left the employment of that company, I've got the right to ask them to say, what information do you have concerning me? And I'm now deciding, let's say I'm moving from one mobile provider to another. I'm now leaving whichever organization to another service provider. I have the right to ask, one, that they give me access to all the information that they have that belongs to me. Now, a company must be able to actually pull the information, all the information that they have that belongs to me, right? And then they must also be able to give me that information and allow me to port that information. So that's another principle that's found in GDPR. And Desmond, you'll correct me here, but it's not really found a lot in data privacy legislation in most of the African countries. Data portability. Pardon?
No. Yeah. No, it's not.
It's one of those stringent rights that's actually found in the GDPR that a lot of countries were like, no, you can miss us on that one. We're not taking that one from it. So there's the right to port your information from one organization to another. Okay, so that's another data subject right. Another data subject right is to say stop, right? Stop using my personal information. Okay. I gave you my personal information for a certain reason. I no longer want you to process my personal information. You've been marketing to me, perhaps, and I given you the consent to do so. You're no longer allowed to do that. Stop. You have a right as a data subject to actually stop or enforce your right to not be marketed to or not have your information processed by an organization that you, even if you had originally given that organization consent to do so, right? Basically,
Amenda, I'm going to interrupt you because it's all sounding really nice, to have that law written down. But how practical is it? And do we have practical examples, say, of countries that, yes, they have a law and they allow their citizens to actually go and ask, I want to see my data, and I would like you to correct it, because this, what you have is what I was 2 years ago, but I've changed. So I want you to update it into my current situation. Yeah. Practical, pragmatic, yeah.
So practically, companies are trying their level best. I mean, with organizations, let me speak about organizations that I've worked with, because to be frank with you, institutions like banks, we can't really use them as an example because they're highly regulated and they've been, doing things the right way for a very long time. So their compliance departments are very mature, right? So with banks, you won't have problems of information that's outdated with them. But with most companies in countries where there is data privacy legislation, they have put measures in place. You'll go on websites, and if you look somewhere on the websites, depending on how well they've been able to actually create awareness and so far as privacy is concerned, they will give you the option to actually update your information. So if you are accessing your profile, for example, on their website, before you are able to continue on their profile, they'll ask you, is this information accurate? Is this information that we have on our system the right information? Would you like to update it? If not, and it gives you the option of actually doing that. So it is practical. Insofar as accessing information, I found that a lot of organizations are still struggling a bit with that one. And the reason for that, and I'll allow you, Desmond, to also elaborate on this. The reason for that is because of the lack of data mapping as well. One, a lot of organizations have not gone through the exercise of actually knowing what information they have and where this information is sitting, right? So that they are then better able to compartmentalize, classify information, and pocket it properly within the organization so as to afford you the effecting of your rights as and when you actually want to action your rights. And Desmond, I'll let you elaborate on that as well.
Okay. Desmond, I'll just ask you to be brief about that, because there's a question I need to ask you, and I think it will not be fair to let you go before you respond to the next question. So please be brief, then I will pose the other question.
Okay. All right, so let's look at it from two angles. From the regulator's point of view, we would need to have a compliance framework. You see, it's not okay to pass data protection laws, set up a commission and go to sleep. The implementation is way different from the reading of the law and the text. You need to have a compliance framework. When you say right to information, what do you mean? And how can that be done? Right to access the information, what do you mean and how can that be done? It includes all the rights, but I tell you what, most of the companies are already doing these things. Look, you go to school, you write an exam, you think there's a problem with your marks, you apply to the school. It's right to information that they hold about you, and the right to access that information and the right to rectify it. That is why you can go back and remark your exam papers, because that data identifies you. If there's an F grade on it, it's an F grade on Desmond. So you are given the opportunity to be able to make these changes. And that is what data protection is about. There's actually an implementation of these things already. What I can say for a fact, this implementation is not thorough. Mm-hmm. So we don't have data subjects getting 100% or 99.9% what they should be getting from data controllers. And two of the rights don't even give us the opportunity to our rights at all. The issue about automated decision making, and then the issue about profiling. These two are a whole lecture for another day. But I can tell you, most of these things are being done. It is not very thorough. The regulators themselves cannot go to sleep. They need to have their own compliance framework within which all the data controllers are going to work. Look at the ICO in the UK. Everything is fine detailed. Even direct marketing is defined. And you are told what you can do and what you cannot do when it comes to direct marketing. I think I'll leave you here for my substantive question.
Okay, thanks a lot. As somebody who has that security background also, you know, are there security concerns where data protection applies? And what are, you know, still tied to that, what is the role of security measures in implementation of data protection?
Okay. All right. So first of all, the role of security would go back in Ghana. We call it the principle 8. That is data security safeguards. So that's where the role of security comes in. Now, I have actually told most of the people that I've practiced security with who pretend they understand privacy that you don't. It's a different ballgame. Yeah. Now, your work as security is only at the point of implementation, where you put in the layered security. You ensure firewalls which are supposed to, you know, filter access from outside into the environment. You put them in place. You put what we call intrusion detection, intrusion prevention in place. You ensure that there is encryption to ensure confidentiality of the information. You are ensuring that your users are abiding by certain passwords convention. You are ensuring that data that is being communicated over the network or over the internet comes with some level of security. These are the roles that you have when it comes to the implementation of data protection. It is limited to the implementation of technical and administrative measures for the purposes of security. Now, there's a bigger security concern when you're speaking about privacy. Now, I would also want people to look at data protection not only from the automated point of view, look at it from the physical point of view. Now, you get an agency who is doing a survey. They are using paper forms to collect the information from you. The first question you ask is, how is this information being transported from the point of collection? And when the analysis is done, how is it stored? And how is the paper, the hard documents even destroyed? So you're looking at paper cabinets with lock and key coming into play when you're dealing with manual data collection. Now, in the automated sense, information that is being collected, you have to do the data mapping, like Amenda mentioned. We have a process called Privacy Impact Assessment. In the GDPR, they call it Data Protection Impact Assessment. This is a mixture of data mapping and risk assessment. So if you do a proper data mapping or data flow, you would identify all the red flags along the channel that the information is being collected, being processed, being stored, being disseminated. All those red flags would be resolved either with security concerns or, will be resolved as risk concerns. And the solutions may either be from a security point of view or maybe an internal process or any other ways by which you're supposed to resolve those issues. So if you take a simple internal use, so I'm going to go into a medical setup. Now, we have a system that 2 practitioners are supposed to access. One is a junior practitioner, the other is a senior practitioner. So he gets access to certain critical health information concerning the patient. And then we have another practitioner who doesn't have that level of access. But then the senior practitioner, for one reason or the other, decided that, hey, get my credentials and access this information so we can work on a patient. There is a privacy breach in that communication. Now, you notice that the original setup does not allow the junior practitioner to access the information. That the technical setup does not allow the junior practitioner to access the information. But by practice, if there is no policy that prevents the senior practitioner from giving his credentials to the junior practitioner, that privacy, that the principle of security would have been breached, because this junior practitioner would now have access to more information than he's supposed to have. In the same vein, if you go into another environment where data is being collected, and the data that probably should be in a database like, let's say, an Oracle or SQL database, which is going to come with the right security, the principle of least privilege being applied on them, that data is probably kept in an Excel sheet. And in an environment where BYOD is, sorry, bring your own device, is one of the principles that is being used. So I take my own laptop to work and I access work files. I can take this Excel sheet home. And if in the house, everybody can access my laptop, maybe my daughter can use my laptop for her work. Now, inadvertently, she accesses these Excel files and finds out that the one minister probably has HIV or maybe meningitis. What happens? You see, there is a breach in the security. So the security concerns is not dotted in bullet points. It comes out of the practice. It comes out of the implementation of your data protection plan. That is why you start your data protection. If you are a corporate, you look at it from a governance point of view. It must be part of your direction as a corporate, what you want to gain out of data protection. It is not only about the regulatory compliance. It's also about value that you are giving to your customers as part of your customer protection strategy. You know, so you look at the bigger picture when you want to address security concerns. It is not enough to bullet point them. It would just be convenient for a discussion. The best approach is get on the ground, do your analysis, identify the red flags, get your security team involved, and let them recommend what solutions will fix all the security gaps that has been identified. So privacy and security, they work hand in hand, but I always want to put security into privacy, because when you discuss the issues of privacy, security is just that one component that is going to deal with the technical and administrative measures.
Okay, we don't have so much time left, but I think that it will be important for you or Amenda to respond to. We go back to the issue of the data subjects and data rights. And I am just wondering, are there instances when, say, state security overrides the rights of a data subject?
That's actually a very.
Do you want me to take that?
Yeah, no, I think we can both share this piece of cake, Desmond. I think with this one, it's a very big one, especially in the African context, because there are a lot of instances where you'll find as an organization you've got certain policies, governance structures, etc., in place in respect of what you're allowed to do and what you're not allowed to do. And then you've got national security, you've got government, which actually trumps your authority as an organization within your organization. So you'll find a lot of organizations sitting in a catch-22 type of situation. One, you've promised me as a data subject that the information that you have is confidential, it's protected. You will not give it to people outside of the people that you have told me you're going to give it to. And maybe let's talk about like a telco, for example. You're able to actually see what calls I make, who I call, SMSs, and that type of information. And here comes a government institution that now says, we want access to Amanda's profile. We want to see who Amanda has been calling for the past 2 weeks or 2 months, or whatever it may be, right? Now, do I, as an organization, just give you that information? What about Amanda's rights to privacy, right? And unfortunately, where we are currently faced, it's in a paper, rock, scissors type of game. Your privacy rights within an organization would be a rock, but government would be that paper over that rock, right? So as an organization, you need to adhere to your national legislation and your national regulations, whatever they may be. So that kind of trumps, it's one of those limitations to your rights. It trumps what the organizations would have been bound to insofar as protecting your personal information. Desmond?
Okay, so I'm just going to move from where Amanda ended. Now, it is not a blank check, even though, you know, security and the issues of national security may give way to privacy. It's not a blank check. I'll tell you why. Most privacy laws provides for the exceptions. So they can say, for instance, that the principles will give way when, say, a police is investigating a suspect and needs the information. But why am I saying it's not a blank check? In Ghana, we have actually made inroads from our human rights court, where the court ruled that the police cannot, I repeat, they cannot search a device, an electronic device of a suspect without a court warrant. So you see, so the police cannot just proceed and say, I'm doing an investigation, so I'm going to get into your phone, provide your passwords, or get a hacker to go into that phone. We have a court, we have a law now from a judicial decision, which has become a precedent, that before the police can do that, they would have to go to court. And mind you, it is not easy for you to get a warrant. You would have to actually convince the judge the investigation that you're having, what exactly you need from that from that device or that information that you are seeking to have. In fact, in our Security and Intelligence Act of Ghana, there is a whole section on how the warrant is even supposed to be drafted. So as a lawyer or a practitioner, you know exactly the kind of information that this state agency is supposed to pick up. But I'll tell you where the problem is. It goes back to the first question we started with, the legal regime. If the courts are not strong, if you don't have the right institutions to make sure that these rights are not violated, they will be violated with impunity, because power corrupts and absolute power corrupts absolutely.
Yes. And I think over and just to add to what you are saying, Desmond, it's 100%. And where we now face, where we are now placed is on the practicality of it. So if you're an organization and you have, you know, national security calling you saying, we want you to shut down perhaps your networks or whatever the case may be, right? Following the process of the courts, that is a long process, right? You have to instruct attorneys, your attorneys need to be briefed, they need to then go to court, their matter needs to be heard, it needs to then be granted. Even if it's an urgent matter, like if it's an urgent interdict that you are seeking, for example. So by an urgent interdict, we're saying we need the court to intervene now. It's something that's urgent. Whatever the national security is doing needs to be stopped now. Doing that as an organization against a national security in a country where you are operating a business, what does it mean for your business? You understand? So there's that politics of it, and then there's that legislative part of it. Yes, you have rights. Yes, you have courts. But what would it mean for your organization? So we as national security, when we call you as an organization and we are enforcing our rights and our authority over you, you want to delay things that are a matter of national security. You know, it becomes a balancing act. It becomes a very political decision for organizations. And that's why in most times, as you were saying, absolute power corrupts absolutely. In most times, it trumps organizations because they are inferior to the government within which, to the government and the jurisdiction within which they operate. So it becomes a bit of a tricky one for organizations. And I think the most important thing, Grace, is that we need to create awareness. We need to train more on data protection. We need to speak more about it. We need to read more about it so that we can find ways, one, as organizations, to protect our data subjects' rights, and also for us as data subjects to actually be able to enforce our rights. We need to be informed.
Okay, thank you so much because you've just summarized our conversation for us. And for those of you who have been listening, we haven't had any questions, so I believe you are very interesting, and people just loved listening to your views. So that's it, because we have to finish on time. We are exactly on time. That's it for the topic, data protection in Africa, legal regimes, and subject rights. I think if people want to engage, maybe what you need to do, Desmond and Amenda, is to indicate your email on the chat, and people can have bilaterals with you. Otherwise, we have to finish. And I want to thank everybody. I want to thank Amenda and Desmond, and I want to thank all of you who have been listening to us. We have to finish on time, and we've done it. Thank you. Bye.
Thank you, Grace.